discuss about an artificial intelligence on the one side, it has occupied the scientists for a decade. There are various purposes for which the artificial intelligence has been used. It is unprecedented, as I pointed out by Professor Acharya and also the direct influence. We cannot predict what will happen, but there are the positive outlook as far as the contribution of humanity is concerned. So I strongly believe that an artificial intelligence, the AI, will play a major role for the betterment of right to health. When we discuss about the right to health itself is an inclusive right. There is no compromise as far as the betterment of right to health is concerned. Let me to tell, more than 145 crores populations in the world, in which least developed countries alone, more than 12% of the population take it more than 45 countries. On the other side, in the developed countries, it occupies more than 70% of the population. On the third side, developing countries. Why I narrate all those things? Is there any uniformity as far as the access to right to health on the one side, access to right to health care on the other side? Because when we discuss about the health, we should discuss about the health. When we discuss about the health care, there is a vast area. There was a discussion and debate to ensure the right to health as a human right. Take an example. In the year of 1948, you are all well aware of it. There is an article called Article 25 of Universal Declaration of Human Rights. They discussed about the right to health. It is the point is very simple. It should not be like a mere empty formality. Rather, it should be a real right to health, so that they included the right to health as a human right. They have clearly and cleverly added a word called right to standard of living adequate for the health, including medical care. When we discuss about the food, when we discuss about the cloth, we should always discuss about the right to health, including medical care. Now, when we look at this article, they are very clear about the sickness, about the unemployment, like that. We will discuss later on about it. There will be a connectivity. Then we go to the another international conventions called International Covenant on Economic, Social, and Cultural Rights. They also mentioned about right to health. Article 12. They used to say the enjoyment of highest attainable standard of physical and mental health. Why? Because when we discuss about these two area, it's a vast concept. On the one side, health, on the other side, healthcare. Third one is what would be an impact of the healthcare and what would be the technological contribution for betterment of healthcare. There is also another convention called Convention on Elimination of All Form of Discrimination Against the Women. There are few articles which narrate about the importance of right to health, particularly Article 12. They used to say we have to eliminate the discrimination against the women in the field of healthcare in order to ensure the equality of men and women, particularly access to healthcare services, including those relating to the family plan. Because in the year of 1979, even we cannot imagine that how the people thought about it and to give a priority to the right to healthcare, particularly for the women. We should take care of it. We should always provide all kind of facilities to take care of their health. And also another conventions called Conventions of the Right of Health of the Child. Because as far as this convention is concerned, it is not only about the health and also about the healthcare services. Why I am just mentioning all those things, the healthcare services is not a recent concept. Time and again, they discussed about it. Whenever they discuss about physical health, they always discuss about mental health. And when we discuss about both concepts, they used to tell we should take care of the child, particularly for the treatment of illness and also rehabilitation of health. In both concepts, they discuss about it. Another one is it is about the health and also the health care. Before discussing about artificial intelligence, we should know about the foundation of right to health and also the right to health care. See, when we discuss about the right to health, parallelly we have to discuss about the intellectual property rights, particularly the TRIPS agreement, agreement on trade related aspect of intellectual property rights. You ask the question, why should we discuss about the TRIPS? What is the connectivity? What is the impact of the TRIPS as far as the right to health and healthcare is concerned? And also, we may ask the question, IPR is a monopoly right. Why should we think about the public right? Because the right to health and healthcare services and human rights, it's a general concept where you have to think about the public. As far as the agreement on trade related aspect of intellectual property rights are concerned, there are articles like Article 7, Article 8, and Article 27, Article 31 of the TRIPS agreement, which narrate about the right to health. How? I will tell one example. During COVID-19, during COVID-19, the world never expected that what will happen, how we have to solve the situation. Then what happened? IPR played a major role to cover the medicine. But there was a fight between the private rights on the one side, public rights on the other side. Take an example, India and also South Africa. Both countries joined together, knocked the door of the TRIPS Council by saying that when people are dying every day, speaking about an IPR is meaningless. When we have a priorities on the one side for public health and the other side for private rights, always public health, public rights will primal over the IP rights. So that there should be a waiver of IP. We should not say that, I have a right, I will always ensure those rights. That has to be compromised in some extent. Even when we talk about the right to health area, there is another area called to promote the public health, particularly access to essential medicine. I'm not going in depth because why? Because that is a wider concept. Essential medicine. I know that you heard about the concept called equitable access to medicine. Equitable access to medicine. When we talk about the access to medicine, there should be equality in case of getting medicine. There should not be inequality as far as the distribution of the medicine is concerned or drugs are concerned. Why? I will tell you. There are least developed countries, they don't have any facilities, even to overcome the difficulties. There is one provision, you are well aware of it, even Indian law, it is there in Indian Patent Act, 92 subclass A of the Patent Act, where they used to tell whenever the people doesn't have any manufacturing capacity, whenever people doesn't have any manufacturing capacity to manufacture the drugs, government can issue the compulsory license to help the people or the country who doesn't have any capacity. They can tell the people, I am going to issue the license, you help them. Because it is a sovereign right of the government to do so. But that can be done, not, at least they have to give the cooling period for 3 years, then they can issue the license. Now, comes on the area called healthcare and artificial intelligence. First question is, what is the role of artificial intelligence as far as promoting the healthcare services are concerned? First one is, it is about diagnostic and treatment. You are well aware of it. How it helps? There are more than 10 artificial intelligence tools and techniques I will tell you. The famous one is Rahealth. I think you are well aware of it. Another one is Moxie. Third one is Marathi. Fourth one is TaxCovid. Fifth one is ChatGPT. The list goes. How the artificial intelligence AI is used for the betterment of and also for the improvement of right to health and healthcare services. I will tell you one example. In the year of 2019 and 20, In India also it happened, but also in other countries it has witnessed. Many of them died in the ambulance itself. Some of them, they died in the hospital itself. Many of them, they don't have any facilities to have an oxygen capacity. Even there are incidents where it happened. The person like an age-old people, they used to help the younger generation. I will be in the world only for 5 years or 10 years. You are all younger generation. I will give the particular oxygen facilities to you. You live it. Anyway, I am in the evening of my life. I am in the evening of my life. I'm telling one or two example where there is no facilities in the least developed countries. There is no facilities in some of the underdeveloped countries for basic need. How AI will help them? It is about diagnosis. I will tell you one example. You all heard about the cancer. As far as the cancer is concerned, artificial intelligence will play a major role. Whether the patient is in a first stage, or in a second stage, or in a third stage, and so on. For an example, I will tell the person who is financially sound and strong, they can use the techniques. They can always get the facilities out of it, and also they can go and see that what is the condition of their health, their body condition, so that they can easily tell and identify. Every year they used to do in the name of medical checkup every year, so that they can easily identify. What about the poor people? How they will know what is their body condition? Even I will tell you, if the people those on this third stage and fourth stage, the cancer cannot be cured. But now what is happening? AI play a major role as far as the diagnosis is concerned, and also the treatments are concerned, and also the AI will help because it's about AI algorithm. AI algorithm plays a major role for the treatment purposes. How it plays a major role as far as the treatment purposes are concerned, and I will tell you, it always take a decision, improve the decision making, and also earlier detection of ailment and also associated care. Third one is as far as checking health through wearable, because it's like a built-in system through which you can easily even AI help what they have to do, how they have to do, what will be the step by step, yeah, what will be the step by step process as far as treatments are concerned. Third one is as far as the uh, the checkup of concern. Take an example. Robot assisted surgery, I think many of you knew about it. Because the excellent, the eminent doctor will be on the one side, they will get the help of AI, and the robotic AI assists the doctor, but you cannot replace the human being. But it will assist the doctor to perform excellently how that particular operation has surgery has to be done. Another one is AI play a major role as far as drug discovery is concerned, and also in a clinical trial. Not only the drug discovery, and also in a clinical trial, and they are playing major role. Then it is about data analysis and also improved diagnosis. And I differ slightly as far as the data analysis is concerned. How I will tell because they are not accurate as far as data analysis is concerned. Sometimes they will give the biased data. So that as far as this one is concerned, there is a lacking point behind it. Then another one is what is the exact issues as far as the contemporary issues of artificial intelligence. On the one side, there is a prostitute. One is a treatment, other one is a diagnosis, third one is a helping, fourth one is they will tell that how the AI will always play the major role. Negative side of AI as far as artificial intelligence is concerned. First one is about ethical issue. I'm not going in detail due to the paucity of time. And the ethical issue, protection of patient privacy and equitable access to health services. Why? Most of the people, those who are living in the least developed countries, in the developing countries, they never ever heard the word called artificial intelligence. Because there is no equality living in the least developed countries, in the developing countries, they never ever heard the word called artificial intelligence. Because there is no equality, but there is some inequality. It's not a fate of the people, but there should be a transfer of technology from one country to another country for betterment of and using the healthcare services. And another one is passion right to self-determination must be protected. In India also it happened. US also it happened. There was a discussion and debate time and again that how we have to use artificial intelligence for the betterment of human being. But they have not settled either in India and also in US. I will tell you what exactly in India is happening. In the year 2015, they have started to discuss about artificial intelligence, how they have to use the artificial intelligence. In the year 2018, they formulated a national strategy for use of artificial intelligence. In the year of 2021, they used to go for standard operating procedures that how we have to use it. And finally, they have not settled it. Why? Because before enacting a legislation, we have to be very careful about it. What it would be the outcome? In which way the self-assessment we use it? And because once you place it as a legislation, then we have to bind. Fourth one is there is a treatment called, you are all well aware of it. Once you bring a legislation, there is a treatment called a national treatment. You have heard about it because there should not be any discrimination between the one country with another country. So that many aspect in Indian government also they are looking at it. So what, in which way, to what extent we can use artificial intelligence as an effective tool. To conclude, what I would like to say, artificial intelligence can use it as an effective tool for betterment of healthcare services, but you cannot replace the human being because without assistance of the human being, no technology will succeed. And also one more thing I will tell you, as far as the healthcare services is concerned, artificial intelligence is a tool, but it is not a only tool for take care of them. Thank you so much. Thank you so much. Thank you, everyone. Thank you.
All right, thank you so much. And now welcome Dr. Rosenberg.
Okay, thank you for inviting me, and it's a great pleasure to be here. My name is Ronnie Rosenberg, and I'm a researcher in contract law and criminal law, and especially in the philosophy in criminal law. So I will talk about the connection between AI and criminal law. So today, artificial intelligence is used only as a support tool to judges in criminal proceedings. For example, AI can assist judges in decisions regarding the release of a detainee before or after trial, helping to assess whether and under what conditions release is appropriate. This assessment is based on the individual's criminal record, personal history, place of residence, level of education, and so on. AI can also support judges in determining sentencing based on the circumstances of the case, past precedents, and the protected value underlying the relevant offense. AI can also assist the police in optimizing how and when forces are deployed and in scanning security camera footage quickly and accurately in order to identify suspects. However, as mentioned, for now, AI remains only a support tool for judges, but the day may not be far off when AI will not just assist the court, it may replace it altogether. AI may not only replace the human judge, but potentially render the entire criminal justice process unnecessary. This brings me to a normative and pressing question that may become very real in years ahead. If AI could replace the criminal trial, for example, by analyzing a defendant's testimony and determining whether he is guilty beyond a reasonable doubt, would that be acceptable in terms of criminal justice ethics? I would like to argue that the answer to this question depends on the underlying purposes of criminal law. The different answers to this question fall broadly into two foundational approaches, the utilitarian approach and the non-utilitarian deontological approach. Utilitarian approaches emphasize the beneficial outcomes that punishment is intended to achieve. For example, according to deterrence theory, punishment serves to deter both individual offender and society at large from committing future crimes. In this view, the offender is not punished because of what he has done in the past, but in order to prevent him and others from offending in the future. The focus is forward-looking rather than backward-looking. By contrast, non-utilitarian justifications reject utilitarian reasoning. According to this view, punishment is justified not because of the positive outcomes it may produce, but because the offender deserves to be punished. Punishment is backward-looking. It is imposed because of the harm the offender has caused and the moral responsibility that stems from it. The justification here lies in retribution, the idea that wrongdoing must be answered with proportionate punishment. A third approach, which I will briefly present here, is the communicative theory of punishment developed by Anthony Duff. Communitarianism emphasizes that every person, whether law-abiding or not, is part of the moral and political community. Unlike deterrence theory, criminal law in this framework is not meant to frighten people into obedience. Rather, when the law finds a certain act as criminal, it seeks to guide the citizen through a process of reflection and recognition that the act is morally wrong. According to Duff, the criminal process is not an adversarial mechanism of the state waging war against the individual. Instead, it is a communicative process aiming to engage the offender in moral dialogue. Even those who have committed offenses are not viewed as outsiders, but as members of the community. For Duff, what matters is not only the punishment itself, but also the criminal trial, which is the most meaningful part of the process, because it provides an opportunity for the accused to undergo a process of repentance, transformation, and reconciliation. Repentance means regret and remorse. When the accused goes through the criminal trial and is eventually punished, we hope that he will come to see the moral condemnation as justified and that he will feel duly punished. We hope that he will come to see the moral condemnation as justified and that he will feel genuine regret for his actions. Beyond repentance, Duff believes that the trial itself should lead to a change in the offender's cognitive perspective. This is what he refers to as reform. It is not enough for the offender to simply feel sorry. He should undergo a transformation in a way he understands and relates to his behavior so that he is less likely to reoffend in the future. That argues that it is important for us as a society that the offender comes to understand the moral condemnation reflected in his actions. In doing so, the offender may express remorse, undergo moral transformation, and seeks to make amends for the harm he caused. Returning to the earlier question, should AI move from being merely a supporting tool to be actually replacing the criminal trial altogether? As mentioned, the answer depends on the underlying purposes of criminal law. If we adopt a utilitarian or retributive view, then perhaps it would be appropriate for AI to replace the criminal process. From a utilitarian perspective, the trial would be faster, more efficient, and more accurate, with a greater capacity to deter both the individual and society at large from committing future crimes. From a retributive standpoint, what matters most is the punishment itself. And if AI can impose a punishment that reflects the offender's moral blame, then it might fulfill that goal. However, if the core criminal justice is not deterrence or retribution, but rather desire for the offender to go through a process of repentance, reform, and reconciliation, then punishment is not the central element. The trial itself is. The trial is where the accused stands before the community, where he must face the victim, his family, and society as a whole and take responsibility. A criminal process that is replaced by artificial intelligence cannot guide the offender through such a moral and personal transformation. In that case, the very heart of criminal justice would be lost. Beyond Duff's account, I would like to add another reason why artificial intelligence should not replace the criminal trial, particularly in the realm of criminal law. In most cases, the general public does not read or study court rulings. Maybe even law students don't read court rulings. Okay? Therefore, we rely on the public nature of the trial and on the dramatic elements of courtroom proceedings to convey the values and boundaries that criminal law seeks to uphold. It is precisely through the drama of the criminal trial that the public becomes aware of the legal and moral judgments being made. This public exposure plays a key role in expressing societal condemnation of the offender's actions and in shaping public understanding of what is legally and morally prohibited. If criminal offenses are understood to harm society, then society should be made aware of them, and this awareness is often created through the visibility and emotional resonance of courtroom proceedings. Let me illustrate this with a recent example from Israel. 7 years ago, 10 teenagers, all around the age of 18, were tragically killed in a flash flood during a hike organized by a gap year program. The group entered a river despite warnings of possible flooding. The head of the program and one of the instructors were later charged with manslaughter. However, the court ultimately acquitted them of manslaughter and convicted them instead of negligent homicide. This case received widespread media attention, and the public became more aware of the differences between various criminal offenses and the required mental elements. If an artificial intelligence system had handled the case, there likely would have been no public drama, and the public might not have been exposed to these important distinctions. In this sense, the educational and symbolic functions of the criminal trial would be significantly weakened, if not lost altogether, if AI will to fully replace the courtroom process. In conclusion, if AI completely replaces the criminal trial, the offender won't go through the moral change we hope for. Also, without the drama of a public trial, people will be less aware and less likely to learn the important values behind criminal law. Artificial intelligence can bring great benefits to humanity, but we must think carefully about how to use it so that the harm does not outrage the good. Thank you.
Okay, now please welcome Dr. Yenga.
Hello, everybody. It's a pleasure to have the opportunity to speak here today. You've all been so welcoming. The students have been so wonderful. So far, I've enjoyed the experience, and I hope that I will be able to add value to you. My topic for today is an investigation into whether data protection law adequately protects the data privacy rights of persons with disability in an age of artificial intelligence, a review of Kenya and South Africa data protection legal framework. Usually when you talk about AI and you bring in the angle of data protection law, a lot of people have questions about how the two are connected. A lot of people cannot understand that, not really cannot understand, but there is no knowledge that the raw material that AI uses to come up with its analysis is the data that it collects from every one of us when we are online, when we live our digital prints. Everywhere we go, when we use apps, when we do shopping, when we use banking, all this information is collected, and this information is stored somewhere, and when it is analyzed by AI, they are able to create the tools that we are able to benefit from. So you cannot talk about regulating AI without talking about regulating how data is collected. The two go hand in hand. And also just in recognition that I think there's only one country that has passed a law on AI. I think it's not country, region, I think it's EU that has passed the AI Act. So for a lot of countries, the laws that are still regulating AI to the extent that they can is the data protection law. So what the research will do, the outline is first I will look at the current state and experience of persons with disability in their daily use of AI. I will look at relevant sections in Kenya and South Africa legal framework. I will review the laws and then I will provide recommendations. Now, before we proceed, it's just important to know, a lot of people will be like, what is the internet penetration in Africa? In South Africa, it's approximately 79%, according to records by the South African government in 2004. In Kenya, the penetration is 72.6, and it's mainly through smartphones. That's how people are able to access data. So the digital realm is something that a lot of people have access to, even in developing countries. And then also just to note that there is no current accurate aggregated data on persons with disability in both South Africa and Kenya. So we have persons with disabilities, but there's no accurate data. We don't know how many people have intellectual disability, how many people may have psychosocial disabilities. But I think like this is a problem that is global, maybe a bit more extreme in the African context. This is just to give you an image of as I will be doing the research. Sorry. Okay. So what is AI? I like to summarize before I get into it, just to tell students, I don't know what is your image or idea of AI. For me, the first understanding of AI was Terminator. I don't know how many of you watched Terminator, the movie, where these machines came to life and they had human intelligence and they took over the world. And basically, AI is machine with human intelligence. Because they have human intelligence, they can learn from data, they can recognize patterns, they can understand language, they can recognize images or faces, and they can make decisions. But AI goes hand in hand. You can't talk about AI without talking about algorithms. And AI algorithms is a set of rules or instructions that allow a computer to process data, recognize patterns, and make decisions without direct human input. Now, for me, when I think about AI algorithm, I have a very complicated relationship with my AI algorithm. When I go to my YouTube AI algorithm, for example, AI observes you as you go online and you the videos that you like, and it creates a profile of you. If I want to know what she likes, I just ask her to show me her YouTube, click on her YouTube. And the algorithm will have videos which she prefers there. If you want to know what kind of a person is, if you want to know things I like, go to my Instagram page, go to my Facebook page. So the AI algorithm, whether you're aware of it, is infused in a lot of the things that we are doing, that we have, whether you're using your search engines. Some people say, I don't use AI. AI is part of your life, whether you are aware of it or not. When you do your banking, everything is, we're living in an age where AI is part of and parcel of everything that we do. Sorry. So this is just saying that there cannot be AI without the raw material, which is our personal data. AI cannot know more than what it can collect from us. It just has a better way to analyze our information. So our personal data is important for AI to be effective. We talk about digital footprints, which is just basically the trail that you leave online, and as your data is being collected. I tried to summarize it because I had a really big presentation. I think it was 40 slides. I don't think anyone wants to listen to 40 slides. So I was just giving an example of where AI is used in ChatGPT and DeepSeek, social media personalization, autocorrect and predictive texting, smart devices, personal assistance. It's used in fraud detection, in banking, online search engines. All of them use AI right now. Online advertising. The advertisements they give her are not the advertisements that my AI algorithm will bring to me. They profile you and know what suits you best. Online translator, hiring companies, then assistive devices, which is very important for our topic today because we are looking at persons with disability. What is that? So, for persons with disability, AI creates a whole new world. For us, AI makes our life comfortable. But for persons with disability, AI gives them an opportunity to participate in the community. They are able to participate because of AI. AI is such a wonderful tool for persons with disability because of the opportunities it creates. For example, you have obstacle avoiding wheelchairs, software that convert sign language to speech, object recognition glasses. We have vision to language tools, text simplification tools, AI-enabled auto captioning, voice recognition software. And in Sweden, they are doing this really unique thing where they have an assistive device which can allow those who are persons with visual disability to run on their own, which is pretty cool. Yeah? However, as much as AI has come with many benefits for persons with disability, it has also come with the cost of their privacy. They often find themselves having to negotiate their privacy rights to be able to have access to assistive devices. If you want to use an assistive device, you have to provide that you're a person with disability. And persons with disability don't like going around telling everyone I'm a person with disability, depending on the individual. Because a lot of times you can be discriminated just by the fact that people realize that you have a disability. Yeah? So their biggest challenge a lot when it comes to using AI and navigating the digital realm is that they all constantly find themselves being forced to negotiate. If you want access into the society, you must give your disability status. Huh? So no privacy. Whether you like it or not, that's just the cost of being able to participate. So although there are many risks, discrimination, surveillance, manipulation, these are just some of the risks they face because they have to give away their privacy to access the digital realm. Now, South Africa, we will be reviewing the law to see if it adequately protects the rights of persons with disability. Now, South Africa has not only ratified the Convention on the Rights of Persons with Disability, it has also ratified the protocol, but South Africa has a Protection of Personal Information Act. And it has an office for the Information Regulatory Office that is up and running. So it's not just a law, but it's a law that is working on the ground. The same can be said for Kenya. Kenya has a Kenya Data Protection Act, and is also a signatory of the United Nations Convention on the Rights of Persons with Disability. There have been cases that have been brought under both acts in Kenya and the act in South Africa. So, while reviewing the data protection law and trying to identify if it does protect persons with disability from risks that arise because of AI, I was able to find, these are some of the challenges that I found. Number one, there's a definition of disability that raises an issue. There's an issue of categorization of disability data. And then there's the issue of consent and accessibility. And then there's the issue of algorithm discrimination. Now, because of time, I will not get into the depths of the definition of disability. I'll summarize it. Now, the definition of who is a person with disability is very important. For those who might not have a disability, you might not understand why this is important because it determines the access of protection you're going to get. If you have a law that has a limited, the definition adopts, there are two main models, but I cannot get to both of them. There's the medical model and there's the social model of definition of discrimination. Now, the medical model is a bit more limited, and it means that some people who suffer from impairments will not be able to qualify as persons with disability, and so they will not get the protection that they need under the law. They will not have access to social security. They will not have access for support because they don't qualify as persons with disability. So the definition in terms of protection is important. If you're able to qualify, and you find like even when you do discrimination cases, when you go to a court of law, if you do not qualify as a person with disability according to the law, then you cannot claim protection under the title of persons with disability. Now, Kenya passed a new law this month. We previously had a very limited definition that knocked out a lot of people from qualifying as persons with disability. We have a new law that adopts the UN Convention's definition of disability, which is good. And this provides more protection it's a more inclusive definition. Now, while Kenya has a new law, and I guess there's opportunity for jurisprudential development in the area, South Africa does not have a general definition of who qualifies as disability. We were having an argument recently whether persons with albinism qualify as persons with disability under South African law. And the only definition that is available under South African law is under the Employment Equity Act. And the definition is extremely limiting. And so you have a situation, for example, if you look at persons with albinism, where some people who might have a visual impairment that is limiting will qualify. But if you're a person with albinism and you can correct your eyesight with specs, you will not qualify. So you will not be able to get protection as a person. You will not have access to social security. So the first recommendation would be that South Africa needs to adopt a general definition of disability that is inclusive and one that adopts a social model a social model for defining disability. And then the second issue I found in both the Kenyan law and the South African law is that disability data is not categorized as special or sensitive data. Now, if you do qualify in the category of special or sensitive data, there's a higher level of protection when your data is collected for use, whether it is with AI, whatever. When people collect your data, there's an extra level of protection that comes with processing your data. Now, because persons with disability don't qualify, they are left in a position where their protection is limited. I do know that the American law does specifically provide that persons with disability qualify as sensitive or special data. And laws that fall under this, if persons with disability fall under this definition, it means that data collectors and data processors have to be more careful in how they process the data. And again, just to repeat, the reason why the identity of being a person with disability, a lot of times if you work in the office and, for example, your employer knows that you have a psychosocial disability, you might not even get employed, depending on the law. So there is a reason why persons with disability should have a right to protect their identity. Not everyone can, but if you can, it is a right that should be protected. And so the argument of the paper that I wrote is that they should be recognized as their disability data should be recognized as special or sensitive data in order for persons with disability to be adequately protected in this age of AI. Number three, this is the American law which provides for that. The third issue that I found is the issue of consent and accessibility. Now, for your data to be used for AI processes, it's based on your consent. You have to give your consent so that your data is used or processed. Now, if you look at the Kenyan law, it defines consent as means any manifestation of express, unequivocal, free, specific, and informed indication of the data subject's wishes by a statement or by a clear affirmative action signifying agreement to the process of personal data relating to the data subject. South Africa, on the other hand, law defines consent as means any voluntarily specific and informed expression of will in terms of which permission is given for the processing of personal data. But we all know, even though you don't qualify as persons with disability, who has read terms of services online? Who reads those? It almost feels like they who read those? They are usually intentionally long, number one. The writing is usually small, and you can barely understand what rights you're giving. So can you imagine the hurdle that a person with disability faces? And that is not only the only problem that comes when it comes to giving consent. Another challenge they face is a lot of times they don't even have access to make this consent. I have a video, a voice recording of, I don't know if we will be able to play it, and you give me, I have a friend who lost, my sister's friend lost her sight at the age of 26. And so she now is learning to navigate the digital realm. I don't know if it's going, if it doesn't play, we will just, would you want to listen to her experience with accessing? Sorry, just give me a minute. Okay, so let me play.
I've never been able to use the M-Pesa app for my very
Okay.
Hey, Shadi.
Sorry, yeah.
So, I do remember you. I've known you for a while. Thank you for reaching out in relation to accessibility on digital platforms. To be very honest, it's honestly a struggle, but we work with what's working. And also, it's dependent on the machine or gadget that you're using. So for me, I use an iPhone, and Also, when it comes to banking is also very. I tried using the KCB app, but I can only use it until a certain point. It will scroll, yes, you'll be able to do a few things, yes, but I can't do the big things. And always keep having to ask. And then there are so many procedures to get to to get to one action. And it requires you to keep doing prompts and sending you a code. And sometimes that code only takes like 10 seconds. Before I type that code, for somebody who is seeing, you'll see the code coming in as a text and be able to type it as fast as possible. But for me, I have to listen to it. So I end up not missing out on that. So and then I have to give my phone to somebody else to be able to key in the code for me. So those are some of the challenges. And the biggest challenge I think for us in Africa and also specifically Kenya is that accessibility is still not something that has been ingrained in our guidelines and even in our jurisdiction. So it's mostly something that people are taking off to just say why perceive, like the way back in the day they would hire one woman and say that they are gender inclusive. It's the same thing they're doing right now. They do one thing and then they say we're very inclusive as a company. So even in terms of Safaricom, they hire people with disability in the farms, but they don't actually actualize the accessibility features, whether it's in digital platforms or physical architecture or structures. We still have a very long way.
So that was my friend just talking about the chat.
Hi, Shaki. So,
Just talking about her challenges in accessibility. So even the idea of giving informed consent almost seems like dreaming, because you're always gonna need somebody else to help you. But I do realize in certain countries, like for example, Instagram and Facebook, they have all these supportive. They have put in place what are they called? They have put in place things which enable persons with disability to be able to access, but it doesn't cut across. Like in countries like Kenya, no one is following up on it, and so they are not able to access. I don't know what is the experience in other countries. If people with persons with disability are able to access some of these platforms more easier, the experience may be different. But in South Africa and Kenya, there's still a bit of a challenge. So consent, our laws, as I was saying, Kenya has a new law. And now as I was going through the law, they actually a provision that is very specific about the digital platform. So that should be helpful, and it will be interesting to see how that is applied online. In South Africa, they have ratified the Convention on the Rights of People, and so we will see how that develops over time. So, and also apart from accessibility, consent brings three issues for persons with disability. There's the issue of it being lengthy, not being able to understand, and then there's the issue of accessibility to even agree to even give your consent. And then the third issue is, what about persons with disability who need support? How can we put in place a system where if I have a cognitive disability or if I have an intellectual disability, that I can get the support that can enable me to give my consent or not give my consent. So these are some of the issues around when it comes to consent. So Article 12 of the UN Convention on the Rights of Persons with Disability brings this idea of supportive decision making, and I think states are still trying to figure out how to include this even in the digital realm. Some of the examples, some suggestions are that they can use guide video walkthroughs or chat boxes, explainers with support decision making. Those are just some suggestions. And I think the third issue is AI discrimination. That is the third issue. I think by now a lot of you have heard about AI discrimination. You do know that AI can discriminate. One of the the reasons AI can discriminate is because it is trained on our data. And we are biased. We can't help it. I guess it's human nature to be biased one way or the other. And so if AI is trained on your data, then AI adopts your biases. A very interesting situation happened in Amazon where they came up with an application using data in Amazon, hiring data over the last maybe, let's say, 10 years. And they used it, they did a test drive. And they realized that the AI, the system that they created was only appointing men. And so they did investigation and they found out that it was doing that because it was trained on data where the person who was hiring in the previous years had a preference for hiring men. And so if the system, if the AI is trained on data that has a bias towards men, then the AI adopts that bias. Another example is now 5 minutes. Oh my gosh, okay. If I dare you right now to Google an athlete, now is when you find that they have a few images of persons with disability. But previously, you would not find an image of a person with disability as an image for discrimination. No, as an image for an athlete, sorry. And then if, for example, AI can, using your data, whether you identify yourself as a person with disability or not, AI can follow your footprints online and identify that you're a person with disability. And using that information, they can use that information to send you job opportunities or use that opportunity to deny you certain opportunities, using that knowledge which you have not disclosed. And that is a form of discrimination. Those are just examples. Now, how can the law deal with AI discrimination? The United Nations Special Rapporteur on the Rights to Privacy in a 2023 report identified 2 principles that can help with regard to using AI ethically. There's the transparency and explainability. So I will summarize it now. I understand it because there are many words. Okay, let me get the point. So transparency basically means that you should know if there needs to be a clear understanding when your data is used for AI processes. You need to be notified so that you can know. And then when you look at explainability, they need to be able to explain how your data was used in a language and in a manner that you can understand. So these are some of the principles that were adopted for the use of AI ethically. Now, within South Africa and Kenyan law, we have 2 sections similar to two sections similar. I'm going to have to jump some things. We have 2 sections similar to section 22 of the EU law. Although the data protection law generally deals with collecting how data is collected and processed, they do have some provisions that deal specifically with AI processes. And what they look at is provisions that deal with automated decision making, which refers to decisions made by algorithms or machines with little to no human intervention. So you can make the argument that data protection law does regulate AI because of these provisions. Section 35 in the Kenyan law and section 71 in the South African law. What both these sections provide is that when a decision is made solely based on using ADM, automated decision making, which is basically AI, where AI is used to make a decision that will impact you, will have a legal effect on you, you need to be notified. You see the principle of transparency and the principle of explainability applies there. But when you look at the Kenyan and South African law, although they adopt this principle, they don't adopt them fully. Section 71 says that if, example, a job decision is made and they use AI specifically to make that decision on whether to hire you or not, you should be notified and you should be given the explanation of how the decision was arrived. Both section 71 and section 35, 71 of South African law and section 35 of Kenyan law. These principles are supposed to help regulate AI discrimination. However, we will not be able to look at the sections, you will find that although it provides a provision for notification, it doesn't obligate them to give you an explanation. So it gives but doesn't give. And then if you look at the Kenyan one, although it gives explanation, it doesn't give you although it gives a provision that requires explanation, it doesn't make it an obligation to notify. So it's like they are giving, but they are not really. The provisions are limiting. And so, okay, so if a person with disability is discriminated against, the sections which would be able to protect them are limited. So, recommendations. Disability data there should be an inclusive definition of disability, number one. Number two, disability data should be specifically protected as sensitive data. There should be more done on clearer rules on accessibility and consent. Number four, the ADM provisions that regulate AI decisions should be more clearer about the principle of transparency and explainability. Thank you.
So I'd like to invite up our panelists to sit for questions. If you're able to sit up here, and I will just open it up for audience questions. If not, I'll have moderator prerogative and have my own questions for everybody. All right, any questions from the audience, students? Excellent.
Okay, I have a question relating to our last speaker. As far as like the laws we currently have protecting like what we're consenting to, I feel like there's a certain like connotation that we're tacitly consenting to the fact that our data is being collected when we're using AI, just with the knowledge that AI uses our data to do what we want it to do for us. Do you think that like that's ever going to be okay in a sense when we understand better how AI is using it, or is the problem more with the transparency of what is being collected or how it's being used?
Okay, this is my own opinion. I hope I get your question right. I do, okay, using myself for example, when you have an opportunity to decide on whether to give your consent or not give your consent, I feel like knowledge is power, and if people actually know there's more transparency on how the data is going to be used and what it's going to be used for, it might give you a little bit of an edge to be able to not consent or to give your consent. So I think it's an issue of transparency. Although maybe for some people it might not be an issue of transparency. Maybe it might be an issue of comfort. Maybe you just want access to those things, but transparency. I feel like most of these digital companies need to be transparent with why they're collecting your data and what they're going to use that for in terms of AI processes. And that's not happening very clearly right now.
Other questions?
Thank you. Thanks for great presentations by all, and thanks for coming out here to Florence. My question is more of a just straight human rights question on the right to health, which is we're all patients, we're all human, so we all have a stake in the matter. You mentioned at the beginning of your presentation, Doctor, that you said health is wealth, which I thought was a very powerful statement. At the end, you mentioned universal health care. America, we have a very problematic healthcare system, I would say, in my opinion. Number one, it's about money, profits over patients. And number two, a a lot of the Americans just lean on the healthcare system for health instead of taking care of themselves. Pills to fix this, pills to fix that, etc. I would love to hear more about the right for health from the perspective of Israel, India, Kenya, and the like, and from a human rights standpoint, and how your country approaches the right to health.
As far as India is concerned, more than 80% of the pharmaceutical drugs, we can call it as a generic drugs. India is a gen always they used to export it. On the other side, in India, we have a healthcare system starting from the primary healthcare system. Take an example. Nowadays in India, it's from the beginning itself. They have a system where they used to help the poor people in each and every state. They used to go to the rural areas because many of them they don't have any knowledge about it. They used to go and door by door. They used to check it, whether they are fine or not. They have appointed the people to check it and also get in a data what kind of healthcare they need. One more thing, as far as the government hospitals are concerned, they are giving a free treatment to the people. Even the primary healthcare center, even in the district hospital, even in the state level, they have an excellent healthcare facilities. The treatment to the people is in a free of cost. There are people who have been affected by of cancer. Nowadays, it's not only the cancer and also the hypertension and also the stroke and also the diabetes. They used to identify the people even in the upper level also, they do their best. And one more thing I will tell you, India is a country where they are exporting their drugs. They are exporting the medicines. The medicines in India, as far as the cost is concerned, is very less. They are exporting the medicine even to the US, United States of America from India. And why? Because in India, the medicine is in a lesser price. Even in the other country, they are too high. And that is the reason why even in India also we have imposed and also they issued the compulsory license as per the drugs are concerned. Despite the fact that there was maybe objection from the other countries. And because the population is too high, because it is more than 140 crores, and India is one of the country they do their best as far as the right to health and healthcare is concerned. Despite the fact that they do not do that is a disparity. Thank you.
Thank you.
So in Israel, we have a law that if you can go to every doctor, public doctor, and you don't need to pay, or maybe a small amount of money. If you break a leg, you can go to the hospital, and they will do everything and surgery, and you will not have to pay. So I think that human rights regarding health is very, very good in Israel.
One more thing I say, as far as India is concerned, during COVID-19, there was a dose because the first two dose, second dose, India successfully did it because, and also not only that, they helped the neighboring countries also, as far as the right to health and healthcare, because that is the one point, because when the people are dying in their home country, they used to say, no, we have to take care of everyone. It's universally, we have to take care of everyone. It is about the brotherhood concept, they followed it. Thank you.
Sorry. Please repeat the question. Sorry.
Just tell us a little bit about healthcare in Kenya, please.
Okay, healthcare in Kenya right now, we have, it's not the same as Israel. Our healthcare is more privatized. We have we have a government, the government provides healthcare. I had a friend, for example, who had an operation. Our monthly, those who are employed are required to remove money monthly. One of my friends had an operation recently, which cost, for example, $1 million, and the state only paid 80,000. It's not even 10%. So healthcare in Kenya is very dire. And if you don't have, government hospitals are lacking in medication, lacking in doctors, lacking in many ways. And even the covering that the national cover that the government provides is it's next to nothing. If you compare what is the percentage, $1 million and 80, they might as well leave you with your salary and you get a private covering, as opposed to the government going around saying that we are providing healthcare and they're not really providing healthcare. In fact, very interesting, a lot of Kenyans go for operations in India in terms of cancer. A lot of them have and always end up going to India for cancer treatment. So in Kenya, the situation is very different. Yeah? The health to right is more on paper and not necessarily tangible for most Kenyans. Yeah.
Thank you.
Hi, so this is like a general question for the whole panel, but so as AI develops and becomes more involved in our everyday aspect of our lives, there's going to be some unfortunate consequences, which we've already seen happened in some cases. And you mentioned, you know, it touches the healthcare system or data privacy for people with disabilities, or eventually taking steps in the criminal justice system. And I was just wondering, like, if you've read any theories or if you have any opinions on your own on how to hold companies who create these AIs accountable for, you know, like what type of liability would be applied. Because I read an article that was provided by Professor Sim Shaw that they're thinking about applying strict liability to AI companies when these unfortunate circumstances happen. So yeah.
In each and every technology, there is an ups and down. But each and every technology, there is a positive and negative. There is no doubt that the AI will rule the country. The AI will rule the world. Because whatever the technology in which there is any disparity or there is any, you know, the negative side, it is a sovereignty of the each and every state to look into that, and also they will find out what they have to do for the particular country. Now there is an universal application as far as identifying the positive side. And one more thing as far as AI technological aspect is concerned, because many of them they invest a huge amount, and when you invest a huge amount, they have to think about the negative side and overcome the difficulties, and also they have to make sure that the AI technology is used only for the betterment of the society.
I think that we are only in the beginning of AI. In 5 or 10 years, we will have AGA. I think AGA. It's IGA. It's general artificial intelligence, which means it will be far beyond what we understand now. So I think, as a philosopher of criminal law or contract law, I think technology will be much more faster than the law. So we cannot restrict technology everything, but we need to be aware of the risks and be cautious about them.
I think I've also had or read about people taking the position about strict liability. And I think right now liability is such a gray area. I was even talking with my colleague, Professor, today when we were having breakfast about liability. What is the position of liability? And I think the biggest challenge with liability is who do we hold accountable? I think if anyone has an answer for that, is it the person who collected the biased data? Is it the person who processed it? Is it all the people who are involved? Do we just hold everyone accountable? Or is it someone who used a good application and did it in the wrong way? Who is to blame? And I think as we stand right now, I wish I had some brilliant idea which I could sell for money or something. But right now, the position that we are in, and I think like everyone assumed the AI Act was going to bring some clarity on that. But so far, I think it's still an area that people are still trying to figure out. Yeah, unfortunately. Yeah.
So we have time for 1 or 2 more questions, maybe this side of the room.
I have a question about disabilities in AI. So concerning children, and as these technologies are used more in schools and parents are consenting for them, do you think any additional protections need to be given for them at all?
So, the data that is collected for children is usually put in the same category. Should be in the category of sensitive data. Now, when it comes to child data, there have been a lot of things that I know. I heard that Australia banned children from access. I don't know. Is anyone from Australia here? but there was news last year that they had banned children from accessing social media. I think and just to go, I saw a case where a teenager killed himself because his mother wouldn't allow him to talk to his avatar, his AI avatar. Like there's bullying, there's so much going on in terms of the online. And when you talk about, I think the only protection that children have currently is that they require they have to be a certain age to access certain things. And the extreme version is, and then there's the issue of age. Is it when a child is 18 that they require their parents to also help with giving the consent, or is it when a child is 17 but they are knowing? And then there's the Australia where you ban children from accessing the digital realm. I'm a bit of an extremist, and I think that children should be banned from the digital realm. That's just my own thoughts. There's so much going on right now in terms, as much as it comes with benefits, there are also disadvantages. So I think it's trying to figure out how can we protect kids and allow parents to have a say in the content that children can access. And also a challenge to that is that a lot of times parents also, the technology is so, the children are more aware of the technology than even the parents. So it's like asking parents to give consent to what they are not even, the child might know more than them about the apps that they want to. So it's I don't know, can you use the word oxymoron? Can that apply in this kind of situation? So like the arguments, they are really nice arguments, but there's no clear line. You either go the extreme where you ban the kids, or you allow the parents to give to also provide consent to allow kids to access these things. But for now, the arguments are I find the arguments very interesting, but there's no definite position on that. But that's a really good question.
Yes, I have a question for Dr. Rosenberg. You mentioned that AI is already being used as a tool in the criminal justice system as a way for judges to consult and determine what needs to be done. I'm wondering if you have any recommendations on how to prevent AI from taking over the criminal justice system in the way you described, to prevent AI from becoming the main source of the trial.
Okay, I don't have any recommendations. I only raised, it's a very good question. I only raised the problem. What will be in the future? Because I think that now we think only about what is actual going on now. That the AI is only a tool for helping the judges. But in the end, another 5 or 10 years with IGA, general intelligence, artificial intelligence, it will replace all of us. Also the trial, the judges, everything. So I only raises the question. I hope it's very moral, interesting questions, and what to do. It's a great question, but I don't have any good response to it. Thank you for your question. Very good.
Well, it's 12:28, so we can wrap up. And sorry. Well, we only have a couple minutes left, so I just wanted to wrap up and thank our panelists for traveling to Italy to share their expertise. Thank you so much, and I will hand the mic over to Dean Houston.
Okay, thank you. I'd like to share with Agnieszka my gratitude for the three speakers and for the audience, and I think we had a good start this morning. So the plan for now is they're finishing to set up the lunch setup, which we can have here. The weather seems to be holding out, so as I said before, please, you can either eat at the seats or you can take your chairs out to the tables that are around. There's space inside as well to eat. And we come back at 2:15. Yeah, that's right. So 2:15. So that gives you a little less than 2 hours, but enough time to relax, enjoy. Conversation is part of a conference, right? The stuff that happens after the panel. So we encourage you to maybe sit with someone you don't know, sit with some of the speakers who are either already given their talks, for giving their talks this afternoon and maybe engage in a little conversation as well. One little warning I want to give that I have from personal experience is the white benches here. Do you see the white marble travertine benches here? They're beautiful, but they're, as always happens this time of year, unfortunately, they're infested with little tiny red bugs that do, especially those of you wearing any white, you might want to avoid sitting on those benches or clearing a path, because I've already been afflicted a little bit. My blue suit is taking it in a little bit. But I've got some